Hey there, Chris Linus with Linus Law Immigration and Criminal Defense. A common question I'm often asked as a defense attorney who does a good bit of DUI work is whether or not you should take a breathalyzer test upon being arrested for DUI. In response to this question, I always say it depends, and that's often the case with legal questions. However, at the end of the day, bottom line, on the spur of the moment, if you've had nothing to drink or had 2 drinks or less, go ahead and take the test. If, however, you've had more than 2 drinks, refuse. And the only exception is if you hold a commercial driver's license, otherwise known as a CDL. In that case, always take the test. Let me walk you through this. When you're arrested for DUI, you're going to get taken to the local police department, and they're going to book you. They're going to get your information, take your photograph, get your fingerprints. And in the midst of this process, they're going to ask you whether or not you want to take a breathalyzer test. This involves blowing into a machine that measures the presence of alcohol in your deep lung air and, by extension, in your blood. It is your choice whether to take or refuse this test. Before you make that decision, the officer is going to read you something called an Implied Consent Advisory, which explains the administrative consequences associated with taking the test and blowing a .08 or above, or refusing to take the test. If you blow a .08 or above, the DMV is going to suspend your license for 45 days to start on the 30th day after your arrest. And after that, you're going to be obligated to have what's called an ignition interlock device in your vehicle for 6 months. An ignition interlock device is a machine that they put in your vehicle, and you got to blow into it and have no alcohol in your system in order to start your vehicle, and then periodically you're going to have to blow into it in order to keep driving your vehicle. Now, if you refuse to take the test, the DMV will similarly suspend your license for 45 days to start 30 days after your arrest, but instead of 6 months with the ignition interlock, a refusal will mean that you're looking at a full year with an ignition interlock inside your vehicle. And if you have prior DUIs, the suspension will remain the same, 45 days, but it'll start immediately, and any ignition interlock periods will be longer. So the key thing you need to understand here is if you blow under a .08, you will not suffer any administrative consequences whatsoever. No suspension, no interlock requirement. So this is where you need to be honest with yourself. How much have you really had to drink? If you only had 2 drinks or less, or had nothing to drink at all, you have a very good chance of blowing under a .08, and you should take the test. If, however, you've had more than 2 drinks, and let's be honest, that's often the case for most people, you should refuse the test. The only exception here is when you hold a commercial driver's license, otherwise known as a CDL. Under federal law, a CDL holder who refuses to take the breathalyzer test is looking at a 1-year suspension of their CDL. And that can jam you up because usually if you hold a CDL, it's the basis for your job. You drive for a living. And under Connecticut law, it's even worse. If you hold a CDL in Connecticut and you refuse the test or blow a .08 or above, Connecticut's going to suspend your CDL for a year. So if you have a CDL, you have nothing to lose. Take the test. You might get lucky and come in under a .08. So to recap, 2 drinks or less, take the test. More than 2 drinks, refuse. And if you hold a CDL, take the test. Now if you like what you've heard here, go ahead and click the link and download our free ebook, 12 Key Things You Need to Know in Order to Avoid or Survive a DUI in Connecticut. Thanks, and have a great day.